Hey guys, let's see. Today, I would like to talk to you about something a little different. We've got an upcoming Supreme Court case. It is Carpenter versus the United States. And this one is important to me, anyway. Who cares if it's important to you or not? Although I think it is. This is a case which demonstrates a couple things. One, that the court is laughably behind the curve in terms of technology, and two, that your Fourth Amendment protections don't really extend as far as you think, and three, I don't even know where I was going with that. Let's just stick with two. Yeah, in the first one, this is a subject that's been dear to me ever since I was a law student and moving into a lawyer. This is an interesting constitutional question: is where are we protected in our privacy from governmental intrusion into our lives? Where does that protection end? And how does the court determine where it ends? So that's what I'm going to take you through today. In this case, United States versus Carpenter, or Carpenter versus United States. Who cares? One of those two. The new one with Carpenter in it, and not the stupid movie with the guy on Mars. So anyway, let me start with just the foundation, in case you're not with me here. The Fourth Amendment text is short, so I'm going to read it in its entirety, and you'll just have to deal with that. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So that is an ugly sentence. Our framers were brilliant. The drafters of the Bill of Rights were brilliant, but they didn't always agree, and that's what has happened with the Fourth Amendment. You had basically two camps, competing ideas on what should happen. The first one was a reasonableness camp. These are people who determined that searches and seizures could be conducted as long as they were reasonable. These were a little more permissive to the idea of government intrusion. Then we had the other camp, who was much more skeptical, and they didn't want this reasonableness standard because they thought, correctly, that it would be that the government would just find pretty much anything that they wanted or that they needed to be reasonable. They would find it was reasonable in the circumstances. And we see this time and time again. I know my buddies out there in criminal defense can attest to this. You can have a rock-solid Fourth Amendment defense, and the court will just come in and determine that, yeah, you know what, that search, I mean, it was reasonable under the circumstances, so it's fine. Or they'll come out with some reason why a warrant wasn't necessary. And that's who the first camp was in this in the drafters of the Bill of Rights and the Fourth Amendment in particular. They thought that a reasonableness standard would sufficiently restrain the government. The more skeptical amongst the framers decided that no, we couldn't have a loose standard that would be so, I guess, subject to opinion, and they wanted warrants for any searches and seizures made. And they wanted a different standard, a probable cause standard, which was kind of an articulable way to suggest how much data was necessary to determine that a warrant should be issued and then that a search could proceed. So what they did, because they couldn't reach agreement, was they just crammed the two ideas together and let us figure it out as we go. This has come up with some interesting results, and not all of them good, not all of them bad. But basically, we have both standards now. We have a reasonableness versus unreasonableness test that happens first. If a search or seizure is unreasonable under the circumstances, then you must get to probable cause and a warrant requirement. There are examples of reasonable searches that have exceptions to the warrant requirement. For example, just a very high level example, and I'll probably do videos on this because I just love this area of law, which is really, that's kind of nerdy. Just a second. But a really high level example is something called the vehicle exception. This is an exception to the warrant requirement. If you have a vehicle that is on wheels and can move, except for very limited exceptions like an RV that is parked in a lot, for example, and plugged in and stuff like that, but which someone is using for a home, that's kind of an exception to this exception. But if you've got your average car or a motorcycle or any sort of mobile object, once a police officer gets to probable cause, at that point, they have an exception to the warrant requirement. And the exception is this idea that you could just drive the evidence away, or that someone could come up and roll away with the evidence that might be there. So the idea of getting a warrant, which could take some time, is too long to do a search. Now, this is based on some pretty old decisions, and the way we communicate now and the way warrants are obtained these days, or I shouldn't say they are obtained, the way warrants can be obtained these days, where technically we could have a judge on speed dial 24/7 or a magistrate, and we can have probable cause statements being drafted in the field on little tablets or computers or iPads or whatever, and sent to a judge for immediate review, and we could literally have warrants in 5 to 10 minutes. We really need to have the court start looking at the ability of technology to override some of these old decisions. But back when these decisions were made, warrants might take an hour, 2 hours, 3 hours, so they created this exception, because if during that couple hours something happened and the car was driven away by someone, or for example they didn't have sufficient cause to actually detain a person, they wanted a way to search a car without having a warrant and without the evidence rolling away. So it's considered a reasonable search at that point if you have an exception to the warrant requirement. There are other reasonable searches. For example, border crossings and ports of entry, customs to the United States, the heightened security of a border entrance, except on the southern border, right? The heightened security of a border entrance puts the government in a position of increased authority. And so the reasonableness scales kind of tip in the government's favor there. And they say, you know what, we don't want someone bringing in a bunch of cocaine or a bomb or something like that through our ports of entry. So our officers are going to have much more license to search someone. Same thing with like an airport, right? TSA they search you in rather dramatic ways that are also completely ineffective. They have this increased authority to search. They don't really need your consent to do it, and they can just go ahead and do it because of the heightened security around airlines have tipped the scales of reasonableness. But for your average search of like a home or a person, this warrant requirement exists, and that's a good thing. I think we need to move back towards the warrant standard instead of farther away from it, especially as communication improves. But I'm rambling now, and that's not helpful for anyone. So you've got these two competing ideas that have come together to create this weird standard we have today. And for the longest time, the courts took this very literally. Persons, houses, papers, and effects were protected against unreasonable search and seizures. And it wasn't really until 1961 in a case called Katz versus United States. Almost all of these are going to be versus United States, but Katz was a guy, he was a gambler, and he used a payphone, okay? And he was sending like results of stuff for illegal gambling. He was on a payphone, and what they did was they attached a wiretap to the outside of this payphone, the phone booth that this guy was using. Oh hell, I mean, I guess depending on when you were born, you may have never seen a phone booth, but they used to have these big glass booths with phones in them. You could dump some money into them and make phone calls. So and Superman was in there sometimes. if you were Katz is in this phone booth and he's making calls about some illegal activity, government slaps a wiretap on it, and then gets this information, arrests Katz for the illegal gambling, right? Well, Katz successfully gets the court to shift their perspective, because Katz didn't own the phone booth, right? So it wasn't his effects, wasn't his person, his house, or paper that they were searching. They just had a wiretap on the phone booth. What Katz convinced the court of was that it wasn't these arbitrary, specific items that were protected by the Fourth Amendment, but rather this idea that people have an expectation about privacy, and when they exercise that expectation of privacy, they're entitled to the protections of the Fourth Amendment. In this case, he wasn't yelling his gambling issues out in the street. He wasn't, walking through a bar talking about how much money he won. He closed himself in a glass phone booth. He had a private conversation via phone. He had an expectation of privacy similar to as if he had gone home, because no one's expecting someone to listen in to your phone booth conversation, right? Especially when you close the door and you're all alone. And that's the situation Katz was in. So they changed the whole standard in 1961, and they said that if someone is demonstrating a reasonable expectation of privacy in their actions, again, there's that term reasonable, then they have the protections of the Fourth Amendment. So that's kind of where we are. That's the standard, right? Because our information is protected so long as we enact that expectation of privacy. So if you've got, for example, if you're sending emails back and forth to someone, maybe you have an expectation of privacy, but if you encrypt that email and give the other person, the other party, a password that would decrypt it, your two-factor keys and all that. Sorry, murder me on the tech jargon. I don't care. You have your own key and their key, and those two keys together allow you to encrypt and decrypt the data. So that makes it much more likely that you want the contents of this email to be private, right? Take notes, DNC. This could help you. But if you exercise this reasonable expectation of privacy in your actions, that could tip the scales in your favor on whether or not the government needs a warrant to go after it. And I'm going to talk about one more case from history to kind of clarify a little bit what's going on in Carpenter. And so bear with me, because again, the court is way behind on technology here. But the next case is United States versus Miller from 1976, because there's like three of these. The first one is firearms. Second one is it's a different search and seizure from 1958. 1939 on the firearms one. By the way, interesting opinion. Read it if you want to know why the government can abridge your Second Amendment rights, even though they're not supposed to be able to. It's because of the garbage in U.S. v. Miller. But anyway, that's another video. In the 1976 version, United States versus Miller, you have this guy, and he has made deposits and withdrawals at a bank. There's bank records that contain incriminating information. Let's see, real specifically. Okay, so here's the syllabus from the court. Respondent, who had been charged with various federal offenses, made a pretrial motion to suppress microfilms of checks, deposit slips, and other recordings related to his account at two banks, which maintain the records pursuant to the Bank Secrecy Act of 1970. He contended that the subpoenas duces tusum, tecum, who cares about Latin, pursuant to which the material had been produced by the bank were defective, and that the records had thus been illegally seized in violation of the Fourth Amendment. Following denial of his motion, respondent was tried and convicted. So, it must have contained incriminating evidence. I don't know exactly what it is. I mean, I could read it to you. Oh, yeah, here we go. He was, let's see. He was illegally distilling whiskey. Very dangerous man, by the way, illegally creating alcohol. So ATF went after him, and there were deposits and records on his bank that contained incriminating information. So what he argues is that by making deposits at a bank, he has sufficiently exercised his legitimate interest in privacy, right? That because he's going to a bank, banks are secret, right? They can't disclose your bank transactions to the world. The Bank Secrecy Act of 1970, of course, tells them that I would assume tells them that you can't just blab information out. But the Bank Secrecy Act, it also kind of damns him in this case. But it's not super important. Here's where it gets interesting. So the government decides that if you volunteer information, if you volunteer information to a third party, then you no longer exercise an expectation of privacy. Specifically, they're talking about volunteering information to a third-party business in the course of business. Katz is depositing these checks and making these transactions that are incriminating. And so he's doing it not with another party to the incriminating act, right? Like, this isn't him depositing money into another person's account, or even if it is, it doesn't really matter, because the bank is inherently involved in this transaction. The bank has to see what money's coming in, whose name's on the checks, where these checks go. They have to make transactions. They have to do further work to go ahead and make these things occur. So the court reasons. Here we go. On their face, the documents subpoenaed here are not respondent's private papers. Unlike the claimant in Boyd, respondent can assert neither ownership nor possession. Instead, these are the business records of the banks. As we said in California Bankers Association versus Schultz, quote, banks are not neutrals in transactions involving negotiable instruments, but parties to the instruments with a substantial stake in their continued availability and acceptance. So the court creates this idea. I'm sorry, they don't create it here. I'll talk about that in just a minute because I'm a liar and I lied about this being the last case, but I'm not going to do the other one super specific. The bank here, or the court here, creates this idea that the bank is party to what's going on between, so they're party C, facilitating the transactions between A and B. So what's happening between A and B isn't necessarily private because they must use party C. In theory, they could have withdrawn and dealt in cash or other things to kind of protect their privacy. So the court has carved out this exception. It's called the third party exception. And the gist of the exception, excluding the language of Miller, and just how this is applied in a very general breakdown is, if you voluntarily give private information to a third party, that information is not subject to the protection of the Fourth Amendment. So that searches of this information are reasonable, typically not requiring a warrant, but they may have some process, like a subpoena. So the case that this actually started from, which I don't think I have pulled up, and forgive my lack of professionalism, it doesn't matter, right? Trust me. The case that this comes from was it was a phone company, and the government wanted to install these things called PIN registers on the lines at the phone company. So what they would do is when they had the old switchboards, when someone dialed a number, right, there was an actual amount of data that was transmitted to the phone company of the phone number being dialed and at what time it occurred, and then that would allow their system, be it people or computers, to actually make the line connection and allow the phone call to go through. So basically they used a series of phone numbers dialed from someone's personal line, in this case in the 60s, so it's not a cell phone, but they've got someone's personal home line or business line or whatever, and the government's kind of watching this person, so they put a PIN register on at the phone company, not on the person's property at all. They're not tapping his phone line, and they, importantly, in this decision, they cannot listen to what's being said on the line. All they can do is register what phone numbers are being dialed and at what time those calls are made. So they can see that every day at 4 p.m. they make a phone call to Jimmy, or whatever it may be. And this was part of the case that was used, part of the evidence that was used to convict someone in some crime. It doesn't really matter. What matters is that that's the establishment of this third-party doctrine, because the court specifically reasons that someone making a phone call must reasonably expect that the phone company will keep a log, basically, will register the phone number that's being dialed and the time it's being dialed. It has to occur for your phone call to take place that the phone company receives the number. At least it used to. Now, I mean, technically, we could have encrypted end-to-end calls where a third party manages the call, but it doesn't actually have access to the encrypted data, the metadata in the call. So, maybe expect to see something like that. Depends on how Carpenter v. U.S. turns out. But on to the instant case. Carpenter versus United States. This is a guy who is accused and convicted of crimes. And the conviction hinges largely on cell phone metadata evidence. And this has been brewing for several years. But listen to how far behind the court is on this issue. This case was originally decided in, I think, 2012, with the facts of the case occurring in 2011. So we're already 6 years of technology past the facts of this case. And when you consider, like, how cell phone technology has exploded over the past 2 decades, really, it's almost unfathomable to think that 6 years have gone by before the courts are tackling this issue, and by the time they have it decided, another year is going to have passed, or maybe another 6 months will have passed, and they're still going to be behind, no matter what they decide, unless they completely rewrite how they look at these cases. But long story short, long story long. This guy made phone calls on his cell phone. When you make a phone call on your cell phone, right, your cell phone has to ping at least 1, usually 2, sometimes 3 different cell phone towers to get an adequate signal to actually make the call occur. You necessarily have to transmit data wirelessly from your device to a tower, and then that tower routes the call however it may need to go. Maybe it needs to go over a physical line to a different tower to then be routed out to wherever this receiving party is. Maybe it goes by satellite. It all depends on the system that the cell phone companies are using and the location of the other party, right? It's a very intricate, complicated network. But necessary to making that call is a transmission of data from your phone to that tower. Now, what the government's assertion here is that everyone who makes a cell phone call, everyone who makes this call, reasonably understands. Remember this when you think of your grandparents making a cell phone call. The court's assertion, the lower court's assertion that's going to the Supreme Court for challenge, and the assertion of the District Attorneys Association, is that everyone who makes a phone call, or at least a majority of people, reasonably understand that the location they're in, at least the tower they're close to, can be pinged, or is pinged and recorded, and the time that they make this phone call. So the tower data and the time are recorded by the cell phone companies every time they make a phone call. And that the average person understands this. I'm reiterating that the average person understands the technical process behind a cell phone call and what happens, because I don't think that that's true at all. I don't think highly technical people, unless they're specialized in cell phones or have some sort of specific hobby interest in how cell phones work, even a highly technical person might not understand how this occurs. I think my understanding of it is rudimentary at best. But these cell phone locations are increasingly being used by law enforcement, starting with the case in Serial, which is the first United States case to really, really delve into cell phone data to prove a murder. And I strongly suggest, if you're bored listening to the podcast Serial, the first season, who cares about the rest? The first one is wildly interesting, and when you at least listen to the episodes about the cell phone metadata and how just unreliable it can be. But I'm digressing, and I apologize for that. Let's get focused. So, in U.S. v. Carpenter, well, hell, I can just read you this is from the brief. The government's contention is that here are the subheadings. Petitioner has no cognizable property interest in his carrier's records. So they're using the third-party exception. They're saying that the cell phone company that's facilitating these calls is recording the data, so it's not his data, right? It's the cell phone company's data. And there's some argument there. But this isn't conclusive to the argument because, really you've got two sections of the Fourth Amendment you're dealing with. If you remember right, the first section talks about people, property, effects, papers, right? Homes. Those are the possessions of the person, and those have you have a property right and privacy in those. I just realized I didn't really talk about this. But basically, the government can't trespass on your property rights for the effect of conducting a seizure either. And I mentioned earlier that up until the cat's sea change in 1961, those property rights were how Fourth Amendment questions were answered. Those property rights are still how Fourth Amendment questions are answered. Actually, Scalia has an opinion in U.S. v. Jones, which is a 2012 case where the government slapped a GPS tracking device on the underside of a car in 2006. So again, court's half a decade behind the facts of the case. But anyway, so the government slaps this GPS detector on someone's car, and then they track the data. Well, the search was considered unreasonable and outside of the scope of, within the protections of the Fourth Amendment, and therefore his Fourth Amendment rights were violated. But the way Scalia gets there is through this property interest. They say that since the government slapped this GPS device on the physical car of the person, that required a warrant, and he didn't really get into the data that was being transmitted, this electronic data. And that's what we're talking about in Carpenter, because basically this guy makes a bunch of phone calls. What they don't really focus on is he's also receiving phone calls. And when you make a phone call or receive a phone call, that data pings off the tower as well and puts your location down. And what's darker is that now, I guess it's not darker unless you don't trust anybody like me, but now when you make not only phone calls, but now when you're using your data, this is we're in 4G land, right? Data is beautifully flowing through the air at any moment. When you're checking your email, for example, or when you're checking the weather, or when you're tweeting, or you're dropping a post on Facebook, or maybe even getting a push notification or a text message, you're pinging those towers. That's being logged and recorded as well. Your location, at least your rough location, is being recorded. Now, if you hit multiple towers in a short amount of time due to any number of things, the government can pretty well triangulate where you are. Or not the government. Yes, the government, but the cell phone companies can triangulate where you are. And if you have a pattern of hitting certain towers at the same time, like I'm going to guess a lot of people hit the same cell phone tower around 10 a.m. on Sundays, every Sunday, right? And you can establish who goes to what church with some level of certainty based on just the sheer amount of telephone, of cell phone towers that are up there and how frequently they're getting pinged. You can start to establish patterns of behavior. And that's where Carpenter and And a whole bunch of people who are concerned about the government's abuse of the Fourth Amendment are making their argument. This isn't just data that's innocuous data that the phone company collects to make a transaction occur, a phone call occur. This isn't even as specific as sending a phone number to the telephone company to help them make that connection. This is much bigger. This is when you make a phone call by cell phone, yes, you're sending a phone number, but you're also sending maybe the location you're standing. If you have GPS on your phone, that data may be sent to the phone tower at the same time as well, and they can actually pinpoint within, maybe 30, 40 feet where you're standing physically when making any given call, when receiving a text message, when sending data online, when checking Facebook, right? This is massively bigger than a pen register getting a phone number and a timestamp. This is phone number, timestamp, location. And that location is where Carpenter's attorneys and all of the privacy foundations who are joining in on this case are hanging their hat. That this goes beyond what people expect a phone company to require to make a phone call. And one of the more interesting briefs, and I'll go into it real quick, and I'm not going to read through it. I know that can be really boring, but I'm going to give you, let's see. It's the empirical, here, where are they? Where are they? What's their name? The Empirical Fourth Amendment Scholars in Support of Petitioner, right? This is a group of law professors who care a lot about the Fourth Amendment and they've submitted empirical data through social surveys, testing people's knowledge on how cell phone calls are actually made. And what they have found in pretty much every survey is that the majority of people have no idea that cell phone companies record your location or even the location of the tower with every phone call that's made. They don't even understand that process. And it's a big majority. They similarly found that a majority of people, in basically every way they can survey this, think that the government getting that data is impermissibly invasive, that it's in violation of the Fourth Amendment right to privacy from the government, privacy in your affairs and your persons, the freedom from being searched and seized. And this is the problem with our government under big data, is that we are creating these digital footprints that are not, they transcend the idea of being just digital. They go into the physical world, they follow us around, and with a sufficient amount of information, and it can all be held by one or two parties, really, you get the ability to make a timeline and to follow someone throughout their day without actually following them. You can surveil someone from a computer days after events occur, even months, and this data is held for so long since storage is so abundant. And partly because the government has pushed these companies to store that data. But you might have years of these records, and a government subpoena to one of these companies can pull all of that location data and start laying out a timeline of where you go. Are you changing religions? Right? This is something that is for a long time in our country been deeply protected. The idea that the right to be a specific religion, whatever you want, has been held a long time. Let's take a counterexample from a very liberal perspective, right? What if evil Donald Trump, who's trying to ban all Muslims from everything, sends the goon squad to look for cell phone data that suggests that a person who used to be a Christian, in whatever denomination, has started attending a mosque because, they've got specific times that they're going to a cell phone tower near a major mosque, and they're pinging during during the worship services. Suddenly, you start to create like a registry. You have the potential to create a registry of religious beliefs that might be unpalatable to a specific person. And if you're of the opinion that someone like Donald Trump is an authoritarian who hates Muslims, it's not a stretch to suggest to that person that Donald Trump could create, through cell phone data, this network of potential Muslim dissidents, right? This is a highly offensive notion to freedom. But even beyond that, I like to frame this idea this way. If you're driving in your car and I'm walking on the street, and we come to the same intersection, right? I'm going to cross the street. I'm on my lunch break at work, and I'm walking to Denny's or whatever. And I look and I see you at the intersection. You're stopped. You're singing Taylor Swift or whatever you're doing, just having a grand old time. You ignore it. I have now seen you. You're in a public place. That's not private. I may even see you again, right? I may see you go through the McDonald's drive-thru as I continue my walk. Or I may see you leaving a massage later as I'm leaving my lunch and walking back to work. Whatever it may be. I may see you a couple times around town. That's fine. You're out in the open. But what if I didn't just see you a couple instant times at random around town? What if I hopped in my car and followed you everywhere I went? Or everywhere you went. I can't follow you where I'm going. Let's say I follow you everywhere you go. And I take a log and I write down every destination in your day. And I do this every day for 6 months. Let's say I even do it for 1 day. What do you do with that? You obviously, most people would tell the person to knock it off. You might call the police, suggest the person's harassing or stalking you, and you'd be well within your rights to do so. But the government is doing this. They're doing this exact thing when they pull this cell phone data. They're not just running into you in a public place. The public nature of your actions becomes more private the more surveillance is done, right? If you're following someone around all day, you're not just spotting them. You're trying to dig into information about them. You're trying to learn some sort of fact or pattern or habit. That transcends, for me, that transcends any amount of reasonableness and should always require a warrant. There's no reason for government to enact this broad ability created by data to track people based on the idea that a cell phone company owns it so the person doesn't, and the person knows that when they're making a phone call, or maybe receiving an email, or maybe sending a tweet, or maybe getting a text, or maybe just their phone's auto-updating the weather, or maybe the GPS satellite information is updating, that information is transmitted to a cell phone tower, stored and recorded and associated with their cell phone on the cell phone company's ends. I don't think most people understand that that's happening. The evidence strongly suggests that it's not, but this is what the court's going to have to wrestle with. They're going to have to wrestle with the District Attorneys Association stating that they really want this information, and believe me, scumbag prosecutors really want that information, and they want it as easy as possible. It makes their jobs way easier if they don't have to deal with pesky warrant requirements. Law enforcement wants this. They definitely want to be able to just go and get this data without having to do any work, without having to show probable cause. They might just have some sort of passing suspicion that someone's doing this wrong. They want to contact a cell phone company and say, hey, go ahead and give me this data. Maybe nothing, but I want to look into it. It's not how it works. That's not how freedom works. And that's what the court's going to deal with. And the really tough situation in all of these things, or the tough fact of almost all these situations, is that you've got a guilty person, right? I don't know what Carpenter did. I don't care what Carpenter did. It doesn't really matter. What he did was presumably illegal. He's been convicted for it. And so a judge is going to look at that, and they're going to have to balance how much they want to protect the Fourth Amendment versus how much a bad guy should be in jail. And that's offensive to liberty in general. But I'm going to get like real rambly here if I don't wrap this up. So I hope you found this video informative. Carpenter versus United States, when the decision comes out, and this is going to be months away, I'll try and do a review of it. It could be a really somber, horrible, angry review if the court rules that that this data is just open to the government to obtain. I think that's the wrong decision. It's based on antiquated ideas. And again, the court is running, especially in digital data, Fourth Amendment questions. They're way behind. They're way behind technology. They're behind everything. They don't have the capability. And I hate to scare you, but remember that like a group of people with the average age of 65 or whatever they are is going to be determining this issue. Can Anthony Kennedy even use a cell phone? I don't know. It doesn't matter. These old guys and a couple ladies are going to be determining this issue, and I really hope they do this in the right way, because we stand to lose a large amount of protection. And believe me, this impacts everybody, whether you think you're guilty of crimes or not. Where you go on the average day, what tower your cell phone pings. By the way, it doesn't always ping the closest tower. So, depending on how it goes, they could put you in places where you're not. And if you think you're not guilty, you don't commit any crimes, one, you're probably wrong. You likely do commit crimes all the time. Two, you think you're okay, but what about the crime that you didn't commit, but your cell phone was pinged on the tower where it did happen? And suddenly someone matching your description is a suspect. You might be in for something, and you may ultimately be absolved from all sorts of things, but you got to hire someone like me. You got to pay thousands of dollars for your legal defense. You have to be labeled a criminal because, believe me, once you're accused, everyone assumes you're guilty. That's just how it goes. And this is stressful, and it's the worst part of many people's lives. So I'm going to wrap it up. Thanks for watching, guys. I'll be monitoring this case. If you like this content, if you don't, let me know. If there are any other cases out there that are interesting, let me know. I'm going to be looking at the Epic Games case pretty soon with the cheaters that's been suggested. And I'll be doing more Fourth Amendment videos that have to do with digital rights, and some that, and many that don't, right? Because our Fourth Amendment, I mean, this is our shield against the government walking through your door at literally any moment for a random compliance check. This is it. That stupid, disjointed sentence is what stops the government from walking into your home or pulling you over at will or stopping you on the street, unless you're black in New York, because they can do that, right? Stop and frisk. But either way, this sentence, this ugly, disjointed sentence, is what stops the government from stopping you at any hour of the day for any reason. And it's really important that we protect it. And yeah, I hope you care. I hope you care.